Hello everybody, welcome to our next installment of Psych and Law. In this case it's Forensic Assessment in Civil Cases, Lecture 11. I don't know, this is the third, fourth one I'm taping today. Kind of on a roll and also setting stuff up in this room. It just seemed like it'd be more efficient. I probably need to be doing some grading, but I'll get to that tomorrow. Let's get enough lectures in the can so that I can hopefully stay ahead of you guys and make your educational experience as good as it can be under the circumstances. What the heck? You know, it's the 1918 pandemic, right? This is almost, 102 years ago. This is not a common occurrence. This is a very different occurrence than most of us, many people have even, seen in their lifetimes. So I hope you're well, and I hope your family's well, and I hope you're doing okay, kind of on lockdown. I haven't been out of the house now. I've been out of the house twice in the last week and a half, and that was simply to take Electron to the vet to get neutered and then pick Electron up the next day to bring him home. That's critical because we got like 4 unspayed females in the house, and Electron's the only male that isn't neutered. So that became an emergency, if you will, or priority now that he's getting to the point where he's thinking about using his equipment, so to speak, but now he can't, so that's that. How many people want to classify that as TMI? You're more than welcome to. Right? Forensic assessment in civil cases. Remember, we did the forensic assessment in criminal cases, and that was that long, 3-4-part lecture. Hugely, who am I? This is kind of the antithesis of the lecture. This is kind of short and sweet. It's to the point. I will admit it's not a very sexy topic. It's but it could be a useful topic, and hopefully we'll have some nuggets, especially towards the end, that might be useful to us in our lives. And I mean directly useful, not just useful in terms of taking an examination, but useful in terms of understanding our life and some of the decisions that we might have to make in our future. So, potential areas of expert testimony in civil cases, so expert witnesses, some of whom could be psychologists depending on the context, right? What are the areas? Well, it might be psychological damage to civil plaintiffs. So you're a plaintiff, you experience some kind of psychological damage as the result of a poorly manufactured product or something that's occurred in a business, and you want to make the case that you've been psychologically damaged and you need to be compensated. Well, someone has to, evaluate the level of psychological damage and make a case in front of a judge or juror that your level of psychological damage is been elevated to the point of needing to be compensated for it. It might be workman compensation claims, so to what extent should we be paid out of workman comp? It might be assessment of civil competence, and this is probably the lengthiest part of this lecture. Psychological autopsy, that is trying to understand the state of mind of someone who's passed away, and this is often something that's done in cases of suicide, and often by insurance investigators, if you will, deciding to pay claims or not. Child custody and parental fitness, we're going to just short one on that, and civil commitment and risk assessment, and that'll take us back to Gavin de Becker, believe it or not. Remember de Becker and his gift of fear. So, let us look at the problem then again for evidence, expert evidence in the courtroom. And the judge is the gatekeeper, and we've already discussed this, but remember that the judge ultimately decides, should this evidence be allowed or should it not? And we're in an adversarial system. We have 2 parties trying to fight it out. They want to use this evidence. Other people want to refute this evidence or limit the introduction of this evidence or completely deny the introduction of this evidence. The ultimate call goes to the judge, right? And the judge is the gatekeeper. Keep junk science out of the courtroom. But we know, judges were typically, before they became judges, judges were lawyers, and lawyers got what kind of education? They went to law school, and that's not to say law school is easy. By no means is law school easy, but it's not a constant revisiting of the scientific method. You guys that are psychology, sociology students in this class, criminal justice students, etc., think about the research methods that you've had to absorb and the understanding of evidence. This is not something that the typical judge might get, right? So what do we know? Daubert versus Merrill? Well, that's one standard of evidence. Kumho-Tyre, that we previously discussed. Kumho-Tyre extended the observation to technical knowledge, just not scientific knowledge, but also technical knowledge. In this case, it was the quality of the rubber used to manufacture a tire. And notice then you're going to need to bring someone in who has the knowledge of the manufacturing process and or the chemistry of the rubber that was used to inform people in judging a suit against a tire company, for example. Unfortunately, though, the problem is, and this is not a slam on judges, this is just an assessment of the reality, that the ability to judge that the judge performs is often in doubt. That they can get out of their depth quite readily, especially when they're being presented with highly technical scientific evidence. Notice that when, well, now I wanted to use the OJ example, and I'll go ahead and do that since I started. But Barry Scheck was an expert on the presentation of DNA evidence, and the judge may not understand this, the opposing attorneys might not understand it, but they wanted to make a case, they wanted to refute DNA evidence, so they needed someone with that level of expertise. And these explanations can be very complex, way beyond what most of us are capable of processing. So, in terms of psychiatric evidence, more in our ballpark, right? The problem of psychological or psychiatric opinion, and remember, evidence in this case might be psychiatric opinion, not just empirically supported evidence, but a psychiatrist giving their opinion, which is then largely opinion. The scientific foundation is variable. We might have empirically based studies and we say, hey, look, this is, we used a laboratory method, we used, control groups, random assignment, etc. to come to these conclusions. Or it may be, on the other end of the spectrum, a psychiatrist saying, well, in my practice, in my experience over 20 years, I have found that this is the likely, and notice that's largely opinion-based. We also have to consider that testimony may be of limited relevance. Just because someone enters testimony doesn't mean that it really informs the jury or the judge at all. In fact, it may be intentionally used to distract. That's always the potential. Experts are often allowed to advance what constitutes an ultimate opinion when juries should be allowed to come to that decision, and that's problematic. And the more technical the testimony, then the less the jury can weigh in on their own decision-making processes, and the more they may rely then on the technical expertise. Expert testimony can open the door to hearsay evidence, and that is talking about what someone said rather than someone directly being interviewed as to what they said, or in terms of findings in this case. Other problems? Well, adversarial system can bias presentation or compromise objectivity. Remember, wealth matters, and if I'm wealthy, then I can hire better attorneys, and better attorneys might have better explanatory powers, they might make a better presentation, they might be more skilled in that regard. Expert testimony is expensive, so again, the state and people of wealth generally have an advantage over middle class and poor people in this regard. We may not be able to hire much in the way of expert witnesses. Even though the state may be required to provide us with expert witnesses, they may not be of the quality of someone who can purchase them, someone who is wealthy. Testing presented evidence is often inadequate. Attorneys do cross-examination on this, and when they cross-examine scientific expertise, they might be out of their depth, they might not be up to the task. And the spectacle of a disagreement casts doubt on the science of psychology. I've mentioned this before. When you have three psychologists saying, hey, this guy is clearly insane, etc., and we say that the other three are saying, no, I mean, I understand that they have a few problems, but it falls way short of the definition of insanity. And then the jurors are looking and saying, these guys call themselves scientists, they don't agree on a basic situation like this, problematic. So Bristow talks about in short, the 5 I's. So what do we need to think about when we're processing expert testimony? Well, ignorance, irrelevance, intrusion, insufficiency, and incredibility. So all of these are aspects of the testimony that might in fact be well processed or not processed well, and then the quality of the testimony could be entirely misleading under these ideas. So that kind of outlines the problem, but what the heck can we do about it? And Well, first and foremost, maybe potential remedies allow clinical opinion testimony only if it satisfies standards like Daubert and Kumo. If it doesn't meet those standards, then maybe it needs to be kept the heck out, right? And what's the other standard while we're at it? Anyone remember the standard to which evidence is evaluated? If you're saying Fry, good job. Okay. Ban the reference of witness as expert witness. So you don't want to say, hey, we're going to bring in an expert witness, right? What you can say is we're going to bring in opinion testimony. And notice that that really then changes the perception of what someone is about to hear. Let me see if I agree with their opinion, rather than, oh, let me listen to what this expert is going to school me on. Limiting the number of experts that can testify. We don't need that many. Keep it, relevant, and don't overdo it. Eliminate bias by employing non-bot witnesses. And this is kind of a radical idea, but that is that witness testimony would be generated by this group who does nothing but generate witness testimony. That is good sideline or a good job for researchers, but I don't think anyone's lining up to make that happen in the near future. And maybe better jury instructions. And jury instructions are going to be something that we'll talk about in 12 and 13 coming up, so more on that later. But these are potential remedies. It doesn't mean they would necessarily be successful remedies, but all of these remedies could be attempted, and we could gather empirical evidence on their efficacy. So let's assess some psychological damages. How might this be done? Well, a couple things we're going to look at is maybe the personal social history. That's the starting place. This can be accomplished by a clinical interview, and perhaps forensic measures can be employed, that is psychological tests to assess. There's no established procedure for this. It's wide open, so it could be done in literally hundreds of different ways. And one thing we know as plaintiffs, that is, if I'm suing someone who has potentially caused me psychological damage, believe it or not, right? There's an incentive perhaps to exaggerate and or fabricate. That is, if I can exaggerate or make up a psychological injury for which I will be rewarded handsomely in tens of thousands, hundreds of thousands of dollars, it might be tempted to do so. Now, one tool that we've talked about way back when we were talking about the police and hiring police was they might be given the Minnesota Multiphasic Personality Inventory, right? Well, there is an F scale, that is a lie scale, right, that determines if someone's telling the truth. And F stands loosely, you could say, think of it in terms of faking. And notice that in this context, faking can be done to fake good or fake bad. Now, in the case of a police officer, if I have a psychological damage, I'm probably going to fake good to get hired. In this case, if I'm trying to get awarded money for psychological damage that someone's caused me, I might want to fake bad, right? What we find is the research says that coaching, though, is successful. So coaching can help people not be detected as fakes in this test, and that then kind of casts the MMPI into further suspicion. Not that there isn't already enough. The MMPI is held up as the panacea because we want to know, kind of like the lie detector test, but we got to think over time that it might become less and less effective because more and more people know how to beat it, so to speak. So, workman's comp claims. What are some of the bases for claims? Well, it could be physical, mental. Loss of an arm causes pain, which leads to depression. And that is over a chronic injury or chronic pain causes depression. Notice that the injury was physical, but the outcome, while in part physical, could be largely psychological. Right? There's mental. Let's say an event causes psychological trauma that persists. So, and we know that one of the more dangerous occupations in the United States is to be a convenience store clerk. And if you're subjected to an armed robbery, pushed around, threatened with death, etc., that might cause significant psychological damage, thus, kind of demonstrating itself in post-traumatic stress disorder and all the consequences of that. And then mental, physical, work-related stress, that is having an ogre of a boss who is constantly overbearing to the point of cruelty and bullying, right? And maybe because they get off on it, because they're sadistic, right, might cause stress, which then causes a physical response of high blood pressure or some other stress-related physical illness. So these are all potential bases for workman compensation cases. And the point in here is who is going to evaluate these and how they're going to present the information within a courtroom setting. Next up, psychological autopsies. These are retrospective, right? And you know, my wife as a paralegal has been working in the contestable claims unit now for a couple of years, and that's what they get. They get the claims that, hey, this insured is filing a claim, but you know, the insurance company says, I don't know if this claim is legitimate. We're going to contest the claim. And sometimes it is in fact suicide. Was this a suicide or was it not a suicide? What is the evidence? And we can do psychological autopsies. The problem is, and we've discussed this before, when we're looking retrospectively, you know, like in determining insanity, were they insane at the time of the crime, right? What we're trying to do is say, what was their state of mind before they did this, before they died? And thus trying to kind of provide evidence that yes, it was a suicide, or no, it was an accident or a murder. So, and this is really around paying death benefits. Is it suicide? Is workman's comp part of the deal? We might, in fact, look at this at legitimacy of a will. What was their state of mind? You know, just because they write down, you know, at the top of it, I was of sound mind and body, doesn't mean that was necessarily the case. So if someone wants to contest it, you got to figure that out. So interviews with third parties who knew the decedent is one way to look at it, and looking at prior records as another component. And none of this is very reliable, unfortunately. Okay, child custody. Now, child custody cases are usually guided by the overarching principle, what's in the future best interest of the child. And as children hit, you know, age 11 or 12, especially 12, then they get a greater voice in the proceedings. But if we're talking about a 6-year-old, it becomes difficult for a 6-year-old to articulate what's in their best interests. So it has to be done from outsiders especially. The emotional stakes are extremely high in terms of custody when we have families, you know, maybe the father wants custody, the mother died, but the mother's family wants a child and they can demonstrate that they were the primary caregiver, and it can be just a gigantic mess. People are really emotionally, you know, energized in these battles. And you need to evaluate a lot of people, and it's not guaranteed that all the people will cooperate with the evaluation, nor will all the people necessarily tell the truth. And you need to render a valuable expert opinion in this individual situation, but it also requires knowledge of child development as a larger picture. So you can see social facts versus social framework testimony can be combined in this situation. It's highly adversarial. Experts need to expect significant challenges and attacks. And these can be personal attacks. Where did you get your license? Oh my God, you know, and all this kind of good stuff. Questions about that? I know. I always ask that during the lecture. Maybe it makes us feel more at home, or more like we're doing normal. We're not doing normal, but we're doing our best. So, civil competence. Basic question. Does someone have the capacity to understand info and make informed choices? Notice, competency in that regard is not a lot different than we were talking about competency to stand trial, etc., or to reject a plea, or to represent oneself. So, basic question, does someone have the capacity to understand info, make informed choices? This could be regarding financial affairs, and at some point, sometimes people, the elderly, might begin to descend into dementia and should no longer be trusted to, you know, take care of their own finances. And in our own case, we had this happen in our family. At some point, it became obvious that my mom shouldn't be dealing with her own finances, and that's when my wife essentially took over my mom's finances. I always kept her informed as to what was going on, but it was clear that she was not going to be able to take care of it herself. A lot of times people, when they begin to experience dementia, one of the first things they might lose is the ability to do mathematics. And if you don't understand math, then it becomes very hard to manage your finances. You need someone else to step in. Now for my mom, she willingly gave us the power of attorney to take care of that. But suppose you have an elderly relative that says, no, there's nothing wrong with me. and yet money is going out foolishly, or they're being taken advantage of, at some point you might raise the issue, is this person competent to manage their own finances, right? Maybe medical or psychiatric treatment. You need to have this done. I don't want to have it done. I don't believe in it, right? And so maybe there's the question of, are you competent to make your own decisions about your medical care or psychiatric care? How about executing a will? You know, suppose all of a sudden my nephew, who is like my sole heir at this point, you know, my nephew says, "Oh my God, I heard you left everything to the cats. What about me?" He might question my sanity, and he might go to a judge and see if he can have me evaluated for my competence. How can he give money to cats? He should be giving it to his loving nephew, right? Advanced decisions about medical care, life-prolonging treatments, these are called advanced directives. What do we know about advanced directives? Do you have an advanced directive? That means if I am incapacitated, this is what I want done with me, right? So I have an advanced directive. You know, I was a motorcycle rider for a long time. It's a good idea to have an advanced directive. You know, it's not that your chance of getting in an accident is necessarily elevated. It probably is slightly. But if you get in an accident in a motorcycle, it can have dire consequences, more so than a car. What do I want done with me? Do I want to be kept on life support as in a vegetative state for the rest of existence? Or do I want to, under certain circumstances, say, hey, this is when it's okay to pull the plug on me. In fact, this is okay when I'm prepared. I would prefer that you do that. Now the downside is, was I competent when I made that decision? Right? So the assessment of competence, okay, I'm going to break. We'll come back to the assessment of competence here, but I'm seeing that the time is a little low, so let's get to part 2 here.